Good morning, Mr. Mikish. So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Mr. Ajete, you were charged with liquor sale without a permit. You are facing up to a year in jail and or a $4,000 fine. You are on bond for the same case. You've not picked up another case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On February 7th, 2025, the officers conducted an undercover vice investigation at a club known as Poppies for operating illegally by selling alcohol without a permit and during prohibited hours. TABC confirmed that the establishment does not have a permit, and the undercover officer observed the defendant working as a bartender. The officer was able to purchase and order a vodka drink. After the officer gave him money, the defendant began to prepare the beverage.
So he's working after hours, you saying?
Yes, Judge. And he was also working at an establishment that does not have a permit.
All right, Mr. Ajete, I'm going to find that there's probable cause to go forward with the case. I ask you to do one thing, not to pick up any new cases. This is now your third of the same case. I am now revoking your bond and I'm putting you in jail. Goes with you. 5,003. It goes with you. Sorry, counsel. I can't just let it happen.
I understand.
Just over and over and over. At some point, he'll get it.
Dismissed. The first one was dismissed.
I understand, but he's on bond for one, and now he picks up another one. So we're still over and over and over. At some point, you're going to get in life, when you do the wrong things, there are consequences. And I can't continue to let it happen. It goes with you.
So
Yeah, just the old. So I'll leave the new case as is. The bond is at $500. On the case where, on the old case, I'll 5,002. 5,002.
Okay.
He will pop up probably on Monday's docket unless he bonds out. I don't know. So if you want to pop on by Monday, we can talk about it and see where we are.
Okay,
Yeah.
thank you.
Thanks.
On the Taylor amendment you took in, he was already at 2501. Do you want to leave it 5,000?
Yeah, 5,001.
Yes, sir.
Yeah. You are Diego Camacho.
Yes, sir.
Mr. Camacho, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, officers were dispatched to Hardy Road in Harris County, Texas, in regard to a minor crash, failure to stop and give information call. Upon arrival, the officer spoke with the complainant, who was also in police uniform. The complainant stated he was driving on the freeway when another vehicle got into his lane and cut him off to make the exit. The defendant got over and hit the front right panel of his truck with the back driver's side of the defendant's vehicle. The complainant followed the defendant, who had his hazards on, but the defendant did not pull over. The complainant continued to follow the defendant's vehicle until the 911 operator told him to stop following. The complainant gave a description of the defendant's vehicle, and a license plate number to the dispatcher. The complainant pulled over and waited for the officers to make a report with an estimated damage of $2,000. The officers ran the license plate and found the vehicle registered to an address on Skinner Road, and the officers traveled to the location and met with the defendant and his father. The officers were given consent to enter the property, look at the vehicle, and observe damage. The defendant stated he was crossing the lane to get over because there was an opening and that the truck accelerated and hit him. The defendant stated the complainant already hit him and was close behind him, so he kept going. The defendant stated he turned down his street and the complainant kept going. The defendant's address is approximately 7 miles from where the accident occurred.
Okay.
So, Judge, if I may, the complainant was only stopped following him while he had his hazards because he was told on the 911 call. And also, I see on the summary that when they run his license plates, this license plate is license plates GS9711. is missing a letter. License plates are usually 3 letters, 3 and 3 numbers. So I'm not sure how running the license plates will go to his house. And additionally, if the correct license plates were also run, then it would actually show that he's not the owner of the vehicle. So I'm not sure how they were able to identify.
Somehow they got to the house, right?
Yes, Judge, they ran it and they got to an address and they went there and met with the defendant.
And then he states that he was driving, right? And the collision occurred, and then he took off. Your license plate, I have no idea. I mean, did they have the full license plate or did they not?
Your Honor, at this time, I don't know. The DIMS just states, as counsel said, just GS 9711. So I don't know in the full office report if it says the full license plate number, but either way, they ran a license plate and they returned.
Somehow they were able to get it to him. I don't know. I mean, if you discover something later that's different, come back and we can revisit probable cause. I'm happy to do it at any time.
Yeah, Judge, and so the reason I say that is because I have the tags for that vehicle, and that's not the license plates that we have on the summary. And that's
I mean, really, we'd have to set it for a formal hearing.
Okay, Judge.
Because I have to give them time to be able to respond to that as well, you know, because that's more, I mean, this is just a mere probable cause hearing.
Your Honor, in the OR, there is the complete license plate. It's the RSG and it continues on. So
I'll check on that, yeah. That's fine, Judge.
So you're saying it was in the DIMS?
in the DIMS, it was missing a letter, but in the full OR, they have the complete license number.
You know, pull the 911 tapes, see what the 911 tape
We'll wait
says,
for
right?
that,
It may
Judge.
be different, you know, maybe they'll have the whole thing on the 911 tape, you know?
Yes, sir.
So, Mr. Camacho, I'm going to find that there's probable cause to go forward with your case. Have you run his license? See, he has a valid license.
Correct, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
That is a condition of your bond. So if I find that you're driving and you don't have a license or you don't have insurance, I'm going to revoke your bond. I'll put you in jail. No more PR bonds.
Eligible, Your Honor.
You understand?
Yes, sir.
Okay, now you have a lawyer. Good job having a lawyer because you do. I will waive your appearance, but it is your responsibility to stay in touch with her. You don't have to come back to court. She'll let you know when you have to come back to court. All right? All right, I'm going to have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it and then you'll be free to go. All right? Thanks. Yes, ma'am.
Right, the council is approaching on page 16. Thompson, come on up.
Can you follow those conditions, Alex,
Just
please?
no contact with the complainant and which other?
I didn't say that, but that's probably a good idea.
Okay.
And then no license, no insurance, no driver's.
Okay.
Inside the Lisa. Go ahead and have a seat in the jury box.
Oh,
This is Lauren Thompson. You are Lauren Thompson. Ms. Thompson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
one moment, Your Honor. It's Thompson, correct?
Oh, sorry.
Okay. Okay, on February 8th, 2025, the officers were traveling on 4300 Luella Avenue in Deer Park and observed a motor vehicle driving with an expired license plate. The officer confirmed with TCIC and CIC and performed a traffic stop. Upon making contact with the defendant, he observed bloodshot eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant admitted to consuming 3 alcoholic seltzers, and standard field sobriety tests were administered. HGN 6 out of 6. Walk and turn 8 out of 8, 1 leg stand 3 out of 4. The defendant was read the DIC and refused to provide a sample, and a blood search warrant was signed and executed.
All right, Ms. Thompson, I'm going to find that there's probable cause to go forward with your case. Any prior to DWIs, and does she have a license?
No priors, Your Honor. I'm running her
No,
license
Your
right
Honor,
now.
she doesn't have any priors.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. As long as you're not using, everything will be fine. If I find that you're consuming alcohol, illegal drugs, I'm going to revoke your bond, put you in jail. Do you understand?
Your Honor, we'd like to state that she did tell the officer that, she had, taken some medication. So she did explain to the officer that she was under some medication. So we would like our concern is the revocation of her license. There's motions for.
I'm not revoking her license. I mean, you may continue to drive, just if it does become suspended at a later point, you just have to be cognizant of that it does, that you're not allowed to drive. So just be careful. You know, I don't know what's going to happen with the ALR hearing and all that. So just be careful. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back to court. Just don't consume alcohol. Don't use illegal drugs. If you're taking or no unprescribed controlled medication. If you're taking medication prescribed by a doctor, that's absolutely fine.
He tells lawyer on it.
Okay, just understand that if you're taking a controlled substance, even prescribed by a doctor, if you take too much, it can be an intoxicant. And if you get in a car, it's bad news. So you just be very, very careful. You understand? Okay.
Thank you.
I'm going to have you sign a receipt. Victoria will have you sign your bond against Felicia, and then you guys are free to go. Thanks. That way.
All right, Judge. Next judge is page. Do you want the ones without attorneys first?
I don't care. Just
Okay, page 1, or I'm sorry, 2,
don't matter.
Alti, Ahmed.
Have you heard from Eddie? Do you know if he's coming? Have you talked to your lawyer? Do you know if he's coming?
I have a attorney, he's already in the courthouse, I think he's in another, courtroom right now.
Yeah, I guess let's wait for the lawyers to see when. Yeah, it's all right. Just take a seat for me, sir.
All right,
Don't
thank
leave.
you. She'll get her reset.
Hey, what's up?
All right, Judge, next is page 6 and 7. Herrera, come on up.
You were Anderson Herrera. All right. Mr. Herrera, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 6th, 2025, the officer was notified by a witness that a former student, the defendant, was inside Spring High School. The defendant was unenrolled from the school by the associate principal on February 4th, 2025, and was told not to return. Spring ISD school records show the defendant is no longer an active student, and the school officer and associate principal advised the defendant to leave on February 6th a second time, not to return. The officer observed the defendant walking on the walkway with other students, and the defendant continued to walk in the officer's direction. The officer observed the defendant pull his hoodie over his head while walking towards the bus ramp area. The officer was in full uniform and gave the defendant a verbal command to stop and follow the officer to his patrol vehicle. The defendant disregarded these verbal commands and began walking in the opposite direction. The officer grabbed the defendant by his left arm and the defendant began to resist, pulling away to the point where he started coming out of his hoodie. The officer verbally commanded the defendant to stop, and the defendant broke loose and used evasive foot maneuvers to gain distance from the officer in the direction of an open parking lot. The officer notified Spring ISD police and requested assistance. The defendant was detained 300 yards from the initial interaction.
So he was where?
He was at Spring High School.
I know, but was he in the outside or was he?
He was on the outside walking towards a parking lot and walking with a group of students when the officer interacted with him.
He's outside. Was he, so any
Still on
point?
the property owner of Spring High School, and they told him not to return to that high school. They told him on the 4th of February not to return to the high school. And he was
Yeah,
on the
I
property.
understand that,
Mhm.
but he's on the outskirts, he's on the sidewalk.
He was walking on a walkway with other students.
Walkway of the school,
It was
near the parking lot of the school, which is owned by the school.
yes, Judge, it was the walkway with other students. And that's when the officer saw him and tried to make contact with him.
I'm just confused. It's already been, it's just a probation.
I mean, I'd like to know where, you know, is he on public property? Is he just on a sidewalk on the outside of the school, you know? Just walking?
He was with other students on the walkway walking towards the
Is
bus.
that,
And further in the DMs, it describes it as the walkway near the portable buildings located north of the band parking lot. So
let's do this, Mr. Herrera. I'm going to appoint you a lawyer today so we can get down and dirty with your case a little bit more. Just take a seat for me in the jury box. Let me get you a lawyer, okay?
Judge, can I get on the sign first?
Oh, yeah. Okay, let me have you sign a receipt real quick. Can you go ahead and appoint him a lawyer so we can, no?
All right, Judge, next is gonna be page 7, no, 8. I'm gonna get it together. Page 9, Jonathan, Felicia, come on up. Hang on one second.
Good morning, Ms. Johnson. Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
yes, Judge. On February 6, 2025, the officer observed a vehicle with an unreadable temporary tag and initiated a traffic stop. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and the defendant stated her license plates were in the vehicle, but she did not put them on yet. The officer ran the plates and did a person check, and the return showed the defendant had been issued a Texas driver's license, but it had been expired since 2015 and was not eligible for renewal. The defendant had 7 previous DWI convictions and an open warrant for DWI.
7 prior DWI convictions, and now she had an open warrant for one?
DWI, yes,
Where?
Judge. You see, Judge.
So she's currently on bond in another county?
This is out of an active open warrant for DWI out of Harris County, Texas, and it gives the cause number. I just don't know which court it is in.
Can you run her license right now, please?
I'll run it, Your Honor.
I think it's terrible, but I want you to miss me on this. You think it's worth the show?
You need to understand, ma'am, that this is absolutely serious business. You know, I have people that send me emails and letters now begging me what to do and try to help them out because they've gotten to an accident where they've injured someone else and they have now been filed a lawsuit where someone else is trying to get $50,000 from them and they're begging, what do? I don't have money. I don't have this. I don't have that. That's why we have car insurance, so that when you are in an accident, you are covered because you never know when it's going to happen. That's why they're called accidents and not on purposements, right? There are many accidents out there that you can, if you maim someone, who do you think they're going to come after? And if they get a judgment after you, it'll trail you for the rest of your life.
We have no license on file for Ms. Johnson in our system.
Stop. If you do not have a Texas driver's license, ma'am, you are not allowed to drive. Do you understand?
Totally.
You will be signing an affidavit with me today. This is a promise that you're going to make to me that you're not going to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Take it seriously. I don't care if there's a burning building and 50 children that need to be saved. your attitude says a lot, and it's really unfortunate. But somehow we have to get through to you, Ms. Johnson. If you don't have a license and liability insurance in your name, you're not allowed to drive. If you show me that you do, then I will take this restriction off. So let's do this. I will give you, I know you're itching to say something, but I've got a bunch of prosecutors here. I will give you a lawyer today. I'll give you a lawyer. You can say your side to the lawyer, but I'm not asking for much. All I'm telling you, if you don't have a license, then don't drive. Do you understand?
That's why I did my part. They're not honoring it. It's right there. I did in November. I'm just waiting on Austin. I've done my part.
I don't know. So
Exactly.
what you need to do is you need to call DPS in Austin and figure out, hey, what do I need to do to get my license? But I can give you a lawyer today. Talk to the lawyer, and the lawyer can also help you out. But until that point, until you have an actual license and insurance, do not drive. Are we clear? Okay. All right. I'm going to have you come up here, swear to this, then I'll have you sign a wreath of Victoria, and I'll have you take a seat in the jury box. We find your lawyer here momentarily.
You
You want to go hire a lawyer?
I have benefits through my company. If you tell me,
It's up to you. I was offering you a lawyer. You don't have to pay for one today, or you can go hire one, whatever you want. You tell me.
I probably just get one because nobody's hearing me. And I'm doing what I'm supposed to do. Is call somebody to.
Okay, it's up to you. You know, we have great lawyers here.
All right, Judge, next is page 12. Norman, come on up.
I need to put "and" insurance in the name, so I need to rephrase that because I didn't put insurance. I want to make sure that there's insurance in there.
I have one.
Who's this?
Page 12, Norman.
Good morning, Mr. Norman. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. Facing blessing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. She can't give you legal advice, ma'am. Can you follow those conditions on Ms. Johnson as well, please?
Yes.
Vic, I'm going to have her sign state's bond conditions as well. Okay, so we're going to do probable cause. If you don't have a lawyer, you may be able to qualify for an appointed lawyer. Just don't say anything.
Yes, Judge. On February 6, 2025, on Westheimer in Harris County, Texas, the officer was dispatched to a DWI investigation. The officer met with a witness who stated he observed another vehicle almost strike his vehicle. The witness exited his vehicle and observed the defendant driving a gray Acura, and the defendant appeared intoxicated. The vehicles were then relocated to a gas station where the witness called the police. The arriving officer observed glossy eyes, slurred speech, swaying, and a strong odor of an alcoholic beverage. SFSTs were conducted, and HGN was 6 out of 6, one leg stand 2 out of 4, walk and turn 4 out of 8. The defendant was read the DIC and consented to breath. The results were .222 and .228.
So the stop was there an accident or no accident?
No, just a witness called. Well, there was an accident where almost struck his vehicle, and the witness called. Yes.
So the witness
The
called.
witness called when they got to a gas station, and the officer arrived to meet them there at the scene. After the witness had told them that the vehicle had almost struck his vehicle, and that, according to the witness, the defendant appeared intoxicated.
Mr. Norman, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. No more PR bonds. Do you understand? Any prior DWIs?
Your Honor.
Please.
No priors, and I'm running his license right now.
You?
License is eligible, Your Honor.
Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed
I can
lawyer?
get one then.
You're gonna get one?
If you can get one.
You wanna apply?
Yeah.
Okay. Deputy Miranda's gonna give you an application. I'm serious. Don't consume alcohol. They're going to call you to go test. If you fail to go test, I will issue a warrant for your arrest. You understand? All right. Hi, do you have an arraignment?
Yeah. Yes, I do have an arraignment. I want to push on probable cause for Benjamin Raymond.
Say it again?
Benjamin Raymond.
Is that from today or yesterday?
He's on docket today.
He's on the jail docket, Judge.
I don't see it, but
Page 20, Benjamin Raymond.
got it. Okay, you want to do it real quick?
Yes, Judge. So on February 3rd, 2025, at 11:40 a.m., the officer ran a license plate search on a vehicle and found the vehicle to have expired registration. A traffic stop was then initiated, and the officer notified the defendant for the reason of the stop and asked for the defendant's driver's license. The defendant provided a Texas ID that did not belong to him, and the officer asked the defendant for a name and date of birth. A search for the provided information showed the defendant's driver's license to be ineligible, and the vehicle also did not have valid insurance. The officer did a person search on the defendant and found the defendant had a bond condition for an ignition interlock device, and the defendant's vehicle did not have an interlock. The vehicle was registered to the defendant.
With the license plate check, however, I don't believe that there is sufficient probable cause for the stop because with the license plate check, there might have been reasonable suspicion to do the initial check. But if without them being able to positively identify that Mr. Raymond was actually behind the vehicle, I don't believe that there is.
Well, but I mean, there's sufficient to stop just what that car, it's not legally on the road, right? It's not registered. So they're gonna, I think it's a good stop because, you know, they get to the car. He's on bond for a DWI, a felony DWI. He's supposed to even have an interlock. He's driving a car without an interlock and then, no, there's probable.
Okay, Judge.
Sorry.
Thank you.
He's had 3 DWI seconds and now he has, I mean,
I understand, Judge.
my God, even more. Yeah, I'm not down with the PR bond on this guy. It just,
He currently does have the $100 PR bond.
they gave him a PR bond. He's got no bond on the felony DWI.
I will also request that the bond remain as is on this charge, on this judge.
I don't know. We'll revisit in a bit. I need to get through.
Okay.
Yeah, okay.
All right, Judge,
Who's next?
next is page 13. Bar, come on up.
Guys, don't send him down because I need homeboy to sign an affidavit. Yeah, Benjamin. So don't send him down yet, please. River Bar?
Yes, Judge. Page 13.
Morning, Miss River Bar. Ma'am, you were charged with assault, bodily injury. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On February 9th, 2025, the officer made contact with the complainant who advised that she and her husband and friends were outside by their motor vehicle hanging out, and the defendant was saying things to them about them being illegal. The complainant and the defendant started getting into a verbal argument, and the defendant started to attack the complainant while the defendant was holding her baby and was reaching around the baby trying to fight. The complainant advised she sustained injuries during the assault and was in pain and was in fear for her life. The officer observed the complainant to have scratches and whelps on her right arm.
Hate crime? Mr. Ms. Riverbark, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with these people and not to be in possession of any weapons. If I find that you're a danger to my public, and I don't care who it is, I will revoke your bond, put you in jail, and I'm going to make your bond sky high. Do you understand? Do we know if alcohol played any kind of part in this?
There's no allegations of alcohol, Your Honor.
And filing those conditions, no contact, no going within 1,000 feet of where this person lives or
Yes, sir.
works, and then no weapons, please?
Yes, Judge.
Ms. Riverbark, you have the ability to hire a lawyer. Okay, we're going to reset your case to give you time to hire a lawyer. I will have you sign a reset with Victoria. After that, I'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, man.
This way. All right, Judge, next is case 14, Singleton. Come on up.
All the ups and downs.
Good morning, Ms. Singleton.
Good morning.
And you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was dispatched to an apartment complex on Dominion Park Drive and met with the complainant, who advised that the defendant is her roommate. The complainant stated the two had a verbal argument over rent, which led to the complainant gathering the defendant's personal belongings and throwing them outside of the residence and onto the ground. Approximately 100 feet from the front door, the defendant then walked towards the complainant and struck her on the face and torso with a closed fist, causing the complainant to lose balance and fall to the ground. The defendant continued to strike the complainant until the defendant's boyfriend pulled her away. The complainant advised she felt pain.
Ms. Singleton, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. It looks like a protective order was issued on the 8th of this month. I would get to know it because if you do something to violate the protective order, like go to the house that's listed in this thing, even if they give you permission, the state can and will file a violation of protective order. It's one of the worst cases you can pick up. Do you understand? You're also not to be in possession of weapons as well, ma'am. No contact, no weapons. Ma'am, do you have the ability to hire a lawyer? Okay.
I can.
I'm sorry?
I can.
You don't want to apply for a court-appointed lawyer?
Thought I had one.
No. You have one during magistration just for that very purpose, but that it ends at that stage. It doesn't carry with you forever. So at this moment, you don't have a lawyer. Do you want one?
May I have a court appointed?
Okay. I have an application on file, Deputy Mayor. Don't worry.
Oh.
I have an application already on file. I will have you sign a Risa Victoria. Don't be a danger to my community because I only have one place for you if you are. Do you understand?
Sure.
You won't get another warning.
All right, Judge, next is case 15.
Can you file no contact, no weapons?
Come on up.
Well, wait.
Spicer.
Good morning, Ms. Spicer. You speak English?
Yes.
Ma'am, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On February 8th, 2025, the officer was dispatched to a maroon SUV driving on 4 flat tires, swerving with a female driving at Hickory Downs Drive. The officer located the motor vehicle with all 4 flat tires and observed the motor vehicle impeding the flow of traffic due to the condition of the vehicle. The officer observed the vehicle turn left and then right and initiated a traffic stop. The officer made contact with the defendant, the driver, and sole occupant. The officer observed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and stumbling, with the defendant drinking 1 beer at 5 p.m. The officer conducted a standard field sobriety test, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand, 1 out of 4. The defendant was read the DIC and declined to provide a sample. A blood search warrant was signed and executed.
Okay, any prior DWIs?
No, Your Honor. And driver's license is eligible.
Got it. All right, Ms. Fleischer, I'm going to find that there's probable cause to go forward with your case. You are, as of now, not to consume alcohol or illegal drugs. It is a part of your bond condition, meaning that if you violate this condition, you will be arrested, you will go to jail, no more PR bonds. Do you understand? Ma'am, do you have the ability to hire a lawyer? Okay, I need you to fill out an application for me. I'll make sure, or I'll see whether you qualify. If you do, then I'll give you a lawyer today. Deputy Miranda will give you an application. I'll have you sign it with Victoria. We'll have you take your seat in the jury box, and then we'll get you with all the paperwork. Please.
All right, Judge, next is page 15 and 16. Taylor, Derek? Open side. Thank you.
You were on bond for a theft case, and now you picked up another theft case. You now stand charged yet again with another theft. You're facing another 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, the complainant observed the defendant trying on sunglasses in their store in the Galleria Mall. And after the defendant left the store, the complainant noticed the sunglasses were missing. The complainant then reviewed surveillance in which he was able to see the defendant putting the sunglasses in his front right pocket and leaving the store passing all points of sale. The complainant then flagged down an officer who was able to locate and detain the defendant. The defendant was wearing the sunglasses on his face and admitted to concealing them. The sunglasses were valued at $350.
Mr. Taylor, I'm going to find that there's probable cause to go forward with your case. I am now revoking your bond on the first case. Goes with you. Unacceptable. We will not continue to give you PR bonds. This is your third one. No more. I will appoint you a lawyer today, but you're staying with me. No going to the gallery at all. Was the prior theft at the Galleria as well?
It was at a CVS, Your Honor.
Okay. No going to any CVS's, and I don't want you at the Houston Galleria. Do you understand? If I find that I don't know if you're going to get out. You get out, you pick up a third case, I'm going to go absolutely nuts on the bond. Do you understand? Goes with you.
All right, Judge, next is page 17. Williams, come on up.
5,001 on the old, and then we'll leave the new one as is. I'm sorry, Vic, what was the last name?
Williams, 17.
Mr. Williams, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 8th, 2025, the officers were dispatched to a disturbance call. The officer met with the complainant, who stated that she and the defendant were in a 7-month relationship. The complainant stated that she shoved the defendant with her shoulder and that the defendant then grabbed her and threw her around. The complainant advised that the defendant was grabbing her face and neck area and has pushed her to the ground, causing pain. The officer observed a laceration on the complainant's hand and a swollen lip. The officer made contact with the defendant, who stated that he lost control and that he admitted to shoving the complainant.
Mr. Williams, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand? If you have contact with this person, if I find that you're in possession of a weapon, I'm going to revoke your bond, put you in jail. No more PR bonds. I want my community safe. I don't care who it is, what color they are, whether they're a small farm animal, I don't care. Everyone gets protected. Do you understand? Do you have the ability to hire a lawyer, Mr. Williams? Okay, I will take a look at an affidavit. I'll see whether you qualify, and then I'll have you take a seat in the jury box. I'll have you sign a reset with Victoria now. Do not leave until you sign our bond conditions. Do you understand? And then I'll have you talk to a lawyer here momentarily.
I work with her, so
I'm sorry?
she worked at the same.
That's going to be an issue. I don't want you to have contact with her. Actions have consequences.
So,
Do you have an arraignment? Do you have an arraignment?
Yes.
Okay, okay, come on.
On, Rashad husband?
Rashad husband, come on up. Do you mind filing those conditions on Williams?
Yes, Judge.
Good morning, Mr. Husband. You were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On February 9th, 2025, the officer was dispatched to an assist the officer call in regards to a shots fired at 1700 Travis Street. The defendant was detained because the officer observed an unidentified individual discharge a firearm, and the defendant was within that group of people. The defendant admitted to the officer that he had 2 ecstasy pills in his right front pocket and that there was an AR pistol in the SUV the defendant was driving. The officer completed a search of the defendant and located 2 methamphetamine pills in his front right pocket, and the defendant informed the officer that he was aware of the AR pistol in the SUV prior to him getting behind the wheel. The officer located the AR pistol on the floor in the second row of the SUV within reach of the driver. The substance was believed to be methamphetamine based on training experience with a weight of 0.61 grams.
Husband, I'm going to find that there's probable cause. Wait a second. He says that the AR is his?
He says he was aware that it was in the vehicle and it was within his reach in the vehicle.
Whose vehicle is it?
I don't believe it says in the DMs, it says he was driving the vehicle.
How do you put it on him?
Allow me to read the full DMs, Your Honor. Yes, Your Honor. He says that he was driving, so it would be that he was in care custody control because he was operating the vehicle with knowledge that the firearm was in there and it was within his reach, his ability to grab the firearm.
Diego Camacho?
Not. How do we know that how do we know that it was in there while he was driving? How do we know that they didn't put it in there after the fact?
The defendant stated that he was aware that the AR pistol was in the vehicle before he got into the driver's seat, before he started driving.
Oh, no. It just said that he was aware. Don't add stuff in.
I'll read the complete DIM.
Read it.
It says the DIM states completely that the defendant informed the affiant, the officer, he was aware the AR pistol was in the SUV prior to him getting behind the wheel, and the defendant informed the officer that the AR pistol could be found in the SUV at the time of his arrest.
Are we to assume that it's his? All he says that he knew that it was in there. You know, it's not his car.
In your honor, just as play, the pleading is that it was on or about his person. So we're just saying he was in his possession because it was in the vehicle he was operating with knowledge that the AR was in the vehicle as well as it being within
Do you
arm's
even know
reach.
when he was operating the vehicle?
I apologize. What do you mean when he was operating?
Was he operating it in the morning, in the afternoon, at 9 o'clock at night? When did all this transpire? What time of day is this?
Let me see, your honor, because based on the DIMS that I see, it appears that
There's a group of people.
it appears
right?
that the defendant was, according to the DIMS, the defendant was found to be at the wheel of a black GMC. So when the officer arrived, he was observed within the vehicle from what the officer says.
Was in the car at the time
At
the
the
cops
time.
get there.
From what the officer says, that he was observed behind the wheel of the vehicle. To be at the wheel of the black GMC Suburban bearing a license plate number that is in the DIMS. So it,
Okay. All right. Mr. Husband, I'm going to find that there's probable cause to go forward with your case. I mean, we take it seriously. I want to make sure if there's enough probable cause that that's, you know. So I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand? If I find that you're a danger to my public, I only have one place for you. So don't. That includes everything. Do you understand, Mr. Husband? You mind filing no weapons, please?
Yes, Judge.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're ducking, you're dodging, you pick up a new case, it's not going to go well for you. You understand? All right, I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box and get your bond conditions. We'll have you sign it, and then you're free to go. All right?
Yes.
All right, Judge, next is case 4. Edward, come on up.
Judge, can you check the right waiting room?
Thanks, that's very good.
Ready?
Yes, sir. Well, no.
Oh, I guess let me. Good morning. You are Mr. Sands, right?
Sir.
Mr. Sands, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated. I'm sorry, not to be probated, with 67 days in jail to give you credit for.
So,
And it looks like you also have a terroristic threat. It looks like they're going to dismiss this case as a result of this plea bargain.
so,
Is that how you understand it?
so,
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Is this what you want to do?
so,
How do you plead to the offense? Guilty or not guilty?
yes. I guess,
I'm sorry?
I guess,
Guilty to the criminal trespass that we talked about. You're pleading guilty to the criminal trespass. Do you understand? And they're dismissing the terroristic to the not guilty. Do you understand? That's the same Tell the judge that.
thank you, sir.
Are you guilty of the criminal trespass?
Sir.
Okay. You know what we're doing, right? That it's going to go on your record. From now on, you're facing a minimum of 30 days in jail, all right? If you go back to, where was it, Alex?
Time rise.
the trespass was at an exam, your honor.
If you go back to this McDonald's, you will end up going back to jail. So you can't go back to this McDonald's, all right? Okay, sir. Good luck. Thanks. Ms. Jewett, is Mr. Craig here? Deputy Miranda, I need your help. I don't know what more of no tolerance you don't get. Your device has been dead.
So Judge, I don't think it's been, it was low
And then it went dead for, I think, a couple of days, but he didn't receive, well, I understand that, Judge, but he didn't receive, I guess the device supposed to send something.
You know when you're supposed to charge the device. You know.
I think it gives you a notice or something that is dying out. And so it didn't give him notice. So he went to pretrial service to have him check it out to find out what was going on with it. But he's been on bond for a very long period of time with no issues whatsoever.
That doesn't give you the justification to do what you're doing.
Just a thing. Yes.
Judge, I will say that I've contacted the device people over at 49, whenever he reported yesterday. They stated that
He only reported yesterday.
yes, we observed.
Unacceptable. Unacceptable.
Well, no, Judge, he reported because I told him that the device, that this was filed. That's the only reason why he reported over there.
The only reason he cared enough to go was because you told him he had to come to court. Otherwise, it would still be dead. It would still be non-functional.
I don't think that's the case, Judge, because it's been functional the entire time that he's had the device. So this is not he's been out for 2 months and the device has not been functioning. That's not it. This was just filed 2 days ago.
Because I wanted to take care of it now. And the reason is that he's on probation for a violation of protective order, picks up an assault of a pregnant person, and then picks up another assault of the same person. And he has another assault dismissed, and they're all the same person. And I told you that there was no tolerance in these cases. And I have here that you have a dead battery since 2/10 of how long was the battery dead?
According to the viewer, I believe it started on the 10th, and then whenever he reported for.
Yes, Judge, that's what I'm saying.
Reported for inspection, we found no issues with the device itself or the charger.
Revoking your bond. You go to jail. I'm sorry. Bond conditions, bond conditions. There's no justification, right? 3 open cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
Judge, it went dead on the 10th, and he immediately went in to go have it checked out because
No, he didn't. No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out.
That's not how it happened, Judge.
Tell me.
When I got the email, I said, hey, there's an issue possibly with your device. He said, I got no notification whatsoever that it was dead. So I will go down there and check it out to see what's going on. I didn't tell him about a court date because I didn't know about the court date at the time. I got the motion first. Then your letter came after the fact. So he went on his own to have it checked out. So if you look at the records, I mean, he's been out for a while and this just happened. 2 days, that's it, Judge.
They tell you that you're supposed to charge this thing on a daily basis. They tell you that you need to put it by the charger every day for a specific amount of time. And if you don't, the battery goes dead. So you know what you're supposed to do.
I said it, Judge, but also if the court remembers that he is also keeping a newborn baby, so maybe he put it in.
That's.
He was tired. I don't know.
It's been dead for 2 days.
It's only been there for 1 day, I believe, Judge, because he went on the 11th, I believe. Today's the 14th.
No, she said yesterday he went. Today's the 14th. That's the
Today's
13th.
14th, I'm sorry, that was the 12th. I don't know why I thought it was the 13th.
So when did he go?
The 12th.
No, the battery goes dead on the 12th. When did he go to pretrial?
He went to pretrial on the 12th, Judge. His battery went dead on the 10th.
Oh, I'm sorry. Okay, battery goes dead on the 10th. Goes to pretrial on the 12th. So he's without a device 2 days. I'm sorry. Goes with you. Just not getting it. I don't know what to tell you, Ms. Jewett, right? There's just no justification. I have 4 kids. It'll take me 2 minutes to put them in front of an iPad for me to go do what I need to do to go wash the dishes, to go take the dog out, to change the litter.
Well, I understand, Judge, but I mean,
There's no excuse. You've got 3 open, very serious cases. And I told him at the outset when he picked up the last violation protective order, there's no talk. I mean, you must comply strictly. And he's just not doing it.
just gonna just reset it for reconsideration on this bond, maybe 2 weeks of month.
So here's the deal. You were right. These cases are ripe. They're old. And it's time to do something with them because the thing is, and what I've experienced is that when we take too long with cases, something invariably happens. You know, cases should only last so long because certain people need certain things. And when they're not getting it, they tend to fall in familiar habits. So these are too ripe. Let me see how old these are.
And then you remember this case was actually transferred over to the
Irity?
yes.
Right. Now I'm gonna keep it now, just because it's, just too much drama. So the violation case is 256 days old. The new violation case is 136 days old. Is discovery complete in both cases, please?
Yes, one confirm. Sorry, his last
The
name
newest case is discovery complete, correct?
Yes, and Judge, if you remember, you may not remember, but this is the case where the wife is saying that what occurred is not really what occurred. Remember, this is the toxic case.
And Judge, either way, discovery is complete on the case.
Okay. Do you have an offer on these cases?
On the most recent VPO, there is not. Let me see if
Can you please put an offer so we can?
I'll let DVD know that you are requesting that they put an offer on. Yes, Judge.
And is there an offer on the felony case?
Felony case, Your Honor, let me see. There is not, Your Honor.
Because the problem, Judge, is they were supposed to be working on the fact that the wife came to court and told the prosecutor she's not participating. So they were going to reeval. That was 2 months ago.
If I may, they did offer him a 2-year deferred upstairs.
Oh, they did?
Yes, Judge, it's just in the notes, not in the actual. They're having a conversation about going back and forth with the defense attorney on that case.
Okay.
To see what they want to do.
So you're set up there 228, okay? We can set the day after if you'd like.
That's right.
Okay, and then what I would suggest is when we come back, it's, play your trial time. So we can just put these babies to bed once and for all. And perhaps the felony court will, you guys can make a global resolution. I don't know, but it's, if I don't do what I'm doing now, I'm enabling. And I'm saying it's okay for you to do what you're doing without any consequence. And it's not. He has to understand that there's consequence. This is the 4th time. It's over and it's over and it's over. And I can't. And I understand that you have to zealously advocate. And I'm not begrudging you for doing it. Right. Certainly not. Of course not. But I can't continue to enable him. So, okay, you got it.
Which case is Jacob revoking?
I'm revoking both VPOs and, I guess 10,000 and 1, 2, 3, 10,004 on each.
Okay.
In both. Yes, ma'am.
I just wanted to give you an update on Heath, DeAndre. The court found no probable cause yesterday. It was UCW, Defense of Others, outside.
I see. Yeah.
I haven't made a decision on what I'm gonna do. He is on bond for a burglary of a habitation for juvenile.
Oh, I didn't know that.
So I'm speaking to juvenile, seeing if they're gonna do anything with his bonds on that one.
I've already found, so there's nothing I can really do.
Yeah, no,
I don't have jurisdiction anymore.
I just wanted
So,
to give you an update because it was back on schedule today. So
we need to do something. So either if you're gonna try to go get indicted, you gotta go get indicted. Otherwise, because we can't just keep it open forever.
yes, Judge, I'm just trying to hear back from juvenile and see.
Yeah, sure.
Kelsey and I, we put all of the no PCs on the last Monday of the month. Okay. And we let them know all the updates and.
Okay, cool.
That's a really good plan, you know?
Right, so the day before, they help, Kelsey, all the little pieces, and that's for an update, and then that's Monday. Yeah, that's why.
Judge, can you send
track of all. I think it's. Okay, that one.
Every once in a while, you got a good idea, right?
They're in there, they're in there.
Hi.
Since again on Mr. Benjamin Raymond, I did look a little bit, his bond was revoked upstairs in felony. No,
Mind bringing up Mr. Benjamin, please?
Judge, can you sign the dismissal for Nikish?
I don't have it.
It's in there.
Okay, done.
Nikish. Also, Judge, yesterday I filed no release instructions on Musgrove.
I signed it.
You signed it? Okay, I just wanted to let you know, I filed the jail release instructions because I spoke with Brad Morris and said, once you sign the jail release instructions, he would dismiss it.
Oh, okay.
Yeah.
Well, there you go.
Okay.
That was on who?
That was on Musgrove.
Okay, I don't remember.
Yeah, he was on docket yesterday.
The state did file, exclusion for here you go. Thank you, sir.
Morning, Mr. Benjamin. You were charged with driving while your license is suspended. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
It's judged. On February 3rd, 2025, at 11:40 a.m., the officer ran a license plate search on a vehicle and found the vehicle to have expired registration. A traffic stop was then initiated. The officer notified the defendant for the reason of the stop and asked for the defendant's driver's license. The defendant provided a Texas ID that did not belong to him, and the officer asked for a name and date of birth. A search of the information provided showed the defendant's driver's license to be ineligible, and the vehicle also did not have valid insurance. And the officer did a person search on the defendant and found the defendant had a bond condition for an ignition interlock device, and that the vehicle did not have the interlock. The vehicle is registered to the defendant.
Johnson?
Let's go through your stuff. And I'm just from 2009. DWI, possession of a controlled substance, robbery, theft, possession of a controlled substance, felony theft, felony theft. Here's my concern. 2018, DWI second. 2019, DWI second. 2019, possession of a controlled substance. Further in the year, DWI second. Possession of a controlled substance, and now another DWI, and now driving on a suspended license. I don't know if you watch the news. Every single day, someone dies from an alcohol-related collision in our county. Every single day. Watch the news. It's really, really unfortunate when a button on a phone and $30 on an Uber will get you to anywhere you want to go in this damn county. Don't matter where you want to go. It's a geographical oddity. It's so easy to just hit one button I don't know what we need to get through to you, Mr. Benjamin, but I don't know if you're going to bond out. You will be signing an affidavit with me today, promising me you're not going to drive. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. Every single time you get behind the wheel, you can be facing 6 months in jail and up to 6 months in jail and or a $500 fine. Do you understand? Do not drive. It's really scary what happens every single day in our county, and it's so tragic. Don't drive.
Williams?
This is the promise that you're going to make to me. All I'm begging you to do is don't kill someone. Please, don't kill someone. You're being held at no bond on your DWI third upstairs as it is. And I don't know, right now they gave you a PR bond in this case, and I don't know if that's appropriate because you scare me. You just, according to this, I find by clear and convincing evidence that you just refuse to comply with bond conditions. So I don't know if I'm going to give him a PR bond, you know? He's driving a car here. He's supposed to have an interlock. He doesn't have one. And so I don't know. So for now, I'm going to have you sign the affidavit. It is a part of your bond condition. Don't be a danger to my county. Otherwise, I will make your bond very, very high. Do you understand? Get a clue, Mr. Benjamin. It's not hard. Come on. Hi, yes, ma'am.
Can you allow a walkthrough for me? No? Okay, thank you. I just
Sorry.
had to ask.
I know.
Morning, Judge, can we approach?
Morning, Judge. Hi, guys.
Have John Williams on docket, Judge.
Okay. Did you get appointed to Mr. Williams?
Yes, Your Honor.
Great. I wanted you to look at probable cause to see if you guys had any issues with it. That's why, or wait, no, maybe that was another case. Okay, tell me.
We were approaching, there's a MOEP and bond conditions that have no contact. The parties no longer live together, but they work at the same place, and there's a chance that their schedules could coincide with each other. State's okay with no threatening and harassing, but.
Have you reached out to the complaining witness? Do you
Yes,
know?
so, I mean, she's not on board, regardless, but I confirmed that they don't live together, so my suggestion was to have no threatening or harassing, that way both of them can work.
But I want to make sure that she's, protected, that she doesn't have any kind of fear.
Yeah, she's not really concerned, from my understanding, but, I would suggest, just keeping the residency restrictions so that, because they don't live together.
Mr. Williams, come up.
And then just, keep the no threatening or harassing contact for that purpose.
Good morning. So your lawyers asked for me to modify your bond conditions to say no threatening or harassing. I will acquiesce, but you have to understand what is threatening or harassing. Doesn't matter what you think. It's what she perceives. So if we're going like this, is that threatening or harassing? It most certainly is, and it can get you in trouble. I don't know what kind of relationship you have with this person, but if it's a type where you're constantly butting heads, you got to be careful. There are many, many vindictive people in this world, and you never know if all they got to do is call, hey man, he's doing this, he's doing that, and then you're going to end up back. So you got to be careful. You understand? Okay, so the only thing I'm doing is I'm modifying the conditions, so no threatening or harassing contact. The residential restriction will still apply, so you cannot go to the house listed in the order for protection. Any more questions, anything?
No, Your Honor.
Okay, all right, good luck.
Judge, you want me to refile that? Because I know the language that's typically in there.
Yeah, I would, just in case, so it's like nice and clean, yeah.
That's good. I'll file that now.
Thank you, Judge.
Oh, and no weapons too?
Yes, sir.
Okay. Hi, how are you, man?
Judge, this is Killian Fernandez. She had fallen off the radar, Judge. We sent her a letter, but she's here now. She's on PTI, and all she needs to do is do a cognitive skills class.
She on bond or what happened?
Yes, sir.
Did she just post bond again or something? Or what happened?
Yes, Judge.
Come up, ma'am.
No, leaving every phone is broken. Page 5.
This is your second PR bond. If it happens, do you speak English, ma'am? Oh, well, we need a translator. Tome asiento, por favor.
Spicer?
Would you have a PTI agreement?
We do, we have a PTI agreement and everything, Judge, but we need to, it was only for 90 days. It was given to us back in October 8th. So the 90 days are up. I need to get it, see if I can get it extended, sir.
And I'm gonna tell you now, the case is, let me see, I mean, it's like a year and a half old, so what does she have to do?
The cognitive skills class.
Okay.
That's it?
Yeah, it's 250 days, so I'll set it out a week, you know, for her to get it done.
Yes, sir.
And then if she doesn't have it done, I'm setting her up for trial.
Well, the thing is that the 90 days are up, so I want to make sure that, you know, she's still on PTI.
Yana, are you still good with it? Fernandez.
It's not what we're talking about.
Oh, I'm sorry. Yeah, so Fernandez is the last name.
And it's going to be us going to. Remember, have your questions for us in the future.
So Venus, what's up, man? What's
first appearance?
What's new, man?
Same old.
Always a pleasure.
Going on with you?
You still in the baseball gig or what?
Yeah, we just started at our first game.
Are you coaching or?
Assistant this season. Yeah.
It's a lot of work, man.
10 seasons as a.
Wow, that's great. Good job, man. Because it's not an easy life. On top of all the other stuff that you have to do, and
Oh, yeah.
and then managing kids in and of itself is
That is not.
no.
It's not easy.
No, but you're a good man. Good job, really.
How are you doing?
You know, it's okay. We're happy to have you. Whenever you're around, we're, you know.
Awesome. I'm gonna hop back in line.
So, Antonio, are you still good?
They're changing it from a cognitive skills class to an anti-theft class, which I think is better, because.
Yeah, that's a good call. I think so too.
And I gave him 3 days. So Monday.
Oh, okay. So let me just admonish her real quick. Let me get the translator here. We'll admonish her and then, yeah. Okay. Okay. And it shouldn't be hard. You know, it's no long less. All right. Coming up, counsel. Good morning.
Morning.
Who are you here?
I'm here with Rick Anderson Ferrer. I was told you had some questions on PC.
Yeah.
Yeah. Have you gone through the facts? Have you gone through the facts? Okay. I don't remember just because we've had so many cases. Will you refresh my memory on Mr. Anderson?
Yes, sure.
Or Mr. Herrera, sorry. I thought that PC was kind of shaky, and so that's why I wanted to appoint a lawyer to see what arguments you may or may not have.
On February 6, 2025, an officer was notified by a witness that a former student, the defendant, was inside Spring High School. The defendant was unenrolled from the school by the associate principal.
Wait. You just said in Spring High School.
Yes. I spoke to the officer to get a better picture of where he was on the campus. He walked through a gate. He was never inside the school itself, but he walked through gates to be on the property of the school.
I mean, is he on the sidewalk?
I have it on Google Maps if I can show you where he went.
Okay, yeah, come on.
Okay.
What do you think?
I think that it's pretty shaky and my client has,
So was here, walk through this gate, get through here to go into these parking lots, to go around here.
school.
This is good.
Did you see?
20 years since I've done that, but.
Take a look so you can see exactly where she's talking about. I mean, he's like,
There's also, you said you went through here. Parking lot. And then this is here where
He was told not to come back by the principal and officers on scene, and he came back to the property and walked through a gate.
Well, it's my understanding that he was told not to come back to the school as a student. I don't think he had entered the property yet. He was basically.
so interesting. Don't come back as a student. Does that mean you can come back as a civilian?
And so where does he go if he has questions about a charter school that he's about to go to? This is the place where he kind of naturally thought that he would go to make such inquiries, and he's standing out there cautiously not entering the building.
Okay, understood.
Right.
So just no
But
PC
I
on the
will
criminal,
now admonish him, don't go near.
but just no PC on the criminal trespass. What about the evading?
Was it fruit?
It's Friday.
Man, I want to go see my Marvel movie. Yeah. I mean, the reviews are bad too. I shouldn't say that. I mean, all right, I'm gonna find a PC.
Judge, may we,
Do you have something else that you want to add?
no, Judge, just, can we just admonish him not to go?
Yes, all right.
Or as a person.
Come up. Don't go back. I'm gonna find no probable cause on both your cases now, but look, you know that they don't want you back. Don't go back as a student, as a person.
Yeah, I'm gonna go.
They've got eyes on you, so you go back over there, it's just gonna end up in a bad way, right? You're on notice now, so even going near the property, it's not gonna end well. You got it?
Yes, sir.
Okay, man, good luck.
Judge, when that help is gonna call?
Yeah.
Judge, right, I need you to have one attorney that needs to.
Okay, yeah. Okay. Come on. Hey, Joe, can I just do this roll call?
Corporation.
What was his last name again?
Herrera.
Herrera.
5A, 6 and 7. Just be allowed to go back at the corporation.
Shush. Shush. All right, Ms. Fernandez, you have been given 2 PR bonds and your case is nearly 250 days old. They are still allowing you to take this plea bargain agreement where if you complete a class, your case will be dismissed. They are giving you only until Monday. So what we will do is we will reset your case until then. If it's not done, we will have to go another route. If you ever miss court again, you will not get any more PR bonds. That will be the 3rd time that you have failed to appear for court and it will not go well. Do you understand? You have a lawyer. It is your responsibility to stay in touch with the lawyer and they can always get a hold of us, but there's no excuse. No tolerance anymore. Okay? Good luck.
Thank you.
Good morning, Mr. Mikish. So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On August 1st, 2024, the officer was dispatched to a disturbance call, and upon arrival, the complainant and security staff stated that the defendant made threats to kill everyone, broke 2 hospital monitors, and was acting aggressive towards the medical staff. The complainant stated the medical staff became scared since the defendant stated, "I will kill you all." The complainant stated she was scared for her life since she did not know what the defendant would do next at that moment.
That doesn't sound right, because I didn't do that.
We'll give you a lawyer and we can go through this with the lawyer. So did he direct it at a person? Is he directing at the entire world? What?
The statement was only made that "I will kill you all." And it says the complainant stated the medical staff became scared, and the statement was that "I will kill you all." That's all we have from the DMs, Your Honor. And then furthermore, the complainant did state she was the only one at the hospital at the time of the officer's arrival, since the rest of the medical staff had gone through a shift change and she was the only one there. So it's not exactly clear who was there when the statement was made. He just said, "I will kill you all."
All right, so who's it directed to? Just.
I don't even know what happened.
The DMs does state that the defendant started to act aggressive towards the medical staff.
And
So
I think that's why she was scared, right?
it appears that because the follow-on saying the defendant was, the complainant said she was scared and the medical staff was scared since he stated, "I will kill you all." So it appears that it was directed towards the medical staff as he was acting aggressive towards the medical staff.
It appears.
Because there's just two distinct
hunch.
There's two distinct sentences, Your Honor, where he acted aggressive towards the medical staff and the complainant stated the medical staff became scared since the defendant stated, "I will kill you all."
I thought I already did time for that too.
Mr. Mickish, I'm going to find that there's no probable cause to go forward with your case, but you need to be careful.
Yeah.
Scaring people can kind of hurt them. You know what I mean?
Your Honor, I don't.
Don't. Mr. Mickish, patience goes a long way.
Yeah.
You know, when you get upset and when you lose control, that's why we have so many people in jail, because they lose control, they do whatever they want to do, and they don't think, if I do this, what's going to happen? If I say this, what's going to happen? Be careful, all right? All right, just hang tight for me in the back.
Hey, I've got Romero Lozano. It's a first appearance.
Okay. Mr. Lozano, come on up.
I'll help you do rear-end accident on 59.
Okay.
Take advantage. He doesn't get right.
Any prior DWIs?
I don't believe he's got any priors of any kind. Right? No.
Good morning, Mr. Lozano. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On February 7th, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The wheel witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard filtered writings were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge, sounds like there's no probable cause because US 50 is not in Harris County, Texas. That's what the road they said it happened on.
Where is it?
It's at US 50. That's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious? Do I need to look it up? I don't know.
Your Honor, the DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway. So they put 50, but then later in the DIMS, they just put 59. So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59 or is it 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas, 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service, which occurred on US 50, but then later said the accident occurred on 59. So
at first glance, this sounds like a straightforward terroristic threat case. Prosecutors say the defendant threatened to kill everyone inside a hospital, leaving medical staff fearful for their safety. But in court, the smallest details can completely change the direction of a case. Judge Fleischer isn't focused on emotion alone. He's examining whether the alleged statement was actually directed at a specific person or simply a broad outburst. That distinction matters because probable cause isn't based on assumptions. It's based on what the evidence actually shows. Watch closely as the judge starts asking increasingly precise questions about the wording of the report. Those questions may seem minor, but they could determine whether this case moves forward or stops right here. The next few moments reveal why accuracy in police reports can make or break an entire criminal case.